this video, we will be looking at the role of applicable law for integrating environmental concerns in investment disputes. So, what is this applicable law? So, before deciding any dispute, that is the first thing that any forum will look into. What are the rules that will apply on the facts of the case to arrive at a decision? So, applicable law, sometimes it may be considered to be a technical formality, but in reality it plays a very significant role, because only based on applicable law the entire issue is going to be decided, and the decision of any forum, including an arbitral tribunal in an ISDS, will decide the facts and the questions based on the applicable law. So, now that we have established how significant applicable law is, we can also talk about, is it actually significant for integrating environmental concerns in investment disputes. I would argue that applicable law takes a center stage, because otherwise if you look at the primary instrument that an arbitral tribunal in an investment arbitration applies, that is bilateral investment treaty, you would only find provisions relating to investor protections. I mean, obviously these days countries are signing a balanced treaty, but as we have discussed in the previous videos, the provision that relate to environment in the IAS are meager, and the scope of it is questioned. So, that is something that we have already covered in the previous videos. So, therefore, when the primary instrument, that is a bilateral investment treaty or a treaty with investment provision, focuses extensively on investor protections, then we look for the applicable law so that the tribunal can apply those rules that relate to non-economic interests, like the protection of the environment. So, this is where applicable law takes a significant place for reconciling environmental concerns with investors' concerns. That is why this is the first topic that we are discussing when we are talking about reconciling environmental concerns in investment disputes. So, applicable law, now that I have underscore the importance of applicable law for integrating non-economic concerns or environmental concerns in ISDS. How does it play out? Once the tribunal is forced to look at certain rules and are forced to apply because it is mentioned to be the applicable law, then all those concerns also gets accommodated while hearing the investment dispute. So, where do we find the applicable law? Ideally, there should be a provision in the bilateral investment treaty or treaty with investment provision, that is in your international investment agreement, titled applicable law. Then the contracting parties can state what are the rules that they want the tribunal to look at while deciding a dispute. One is that. But if we look at the practice, we do not see an applicable law provision in an IAA, in an international investment agreement. So, then what happens? Then sometimes the tribunal randomly states that it will look at, it will apply rules of international law, it will apply the domestic law, randomly states that. And that is an approach that we could probably see in LG&E versus Argentina case also. So, the tribunal spelt out that it will apply international law, then it will apply Argentine law. That is something that we could see. Otherwise also, if we look at it, even when the tribunal is not explicitly answering the question of applicable law, we can see that the tribunal has applied the BIT provisions, then international law, general principles of international law, customary international law, then the domestic laws of the host state. Then sometimes it has even referred to the past disputes, past decided cases as well. Obviously, there is no concept of precedent, but past decided cases has a persuasive value for the subsequent cases. So, these are the things that the tribunal look at. If you look at MTD versus Chile, we do see that both the parties did not contest on the applicability of international law, but the parties contested whether international law should be applied to decide the question if Chile has breached the conditions mentioned in the investment contract, right. So, there for specific question the party may argue that international law is not applicable, and especially the host state may argue that this question should be examined only from the host state laws perspective. So, that contest also happens. So, arbitral tribunal essentially looks at the question of what is the applicable law for this particular dispute. So, we can even say technically that is the first question of law a tribunal sort of answers, what is applicable law with regard to this particular dispute. Okay, keeping that aside. Now, let us say ideally it should be present somewhere, right, in an international investment agreement. If the parties had not mentioned it in international investment agreement, even after the dispute is initiated, the parties may agree that these are the laws that will be applicable to this particular dispute. Technically, this is a possibility, but if we look at the past cases, we see rarely such an approach has been taken, right. So, then where do we go? Even with regard to the applicable law being mentioned in the International Investment Agreement is also not very common practice. But one example that we could see is Article 1131, first paragraph of this particular article of NAFTA. It talks about applicable law. It clearly says that first the provisions of NAFTA agreement will be applicable, then international law will be applicable. So, that is there. So, one, you look at the international investment agreement, otherwise the parties can have the option of agreeing to an applicable law post the dispute has been initiated. Even that is also not very common. So, what does a tribunal do when the tribunal has to decide the question of what is going to be the applicable law for this particular dispute? We do see the popular approach that they take is they refer to the arbitration rules under which the dispute is initiated. As we know, the most two popular applicable rules are either the exit convention and exit arbitration rules, or in case of an arbitration where exit party is not involved, then we do see UNCITRAL arbitration rules. It is very popular for investment arbitration. So, then the tribunal may look into what is it that is provided in the exit convention or in the UNCITRAL arbitration rules. If we look at exit convention, article 42 talks about it. Article 42 states that the laws that the contracting parties have agreed to be applicable law, that will be applicable on the dispute. If the contracting parties have not agreed, then in that case the laws of the contracting party, including the rules relating to conflict of laws, will be applicable as well as international law. So, we can see that exit convention has given a scope for applying the host state laws and international law on an investment arbitration. That is something very clearly it comes from article 42, right. So, at the same time we can also see what extent this have the domestic laws and to what extent international law has to be applied. That is not something that clearly defined in article 42. So, article 42 is not talking about the weightage to be given to a domestic law or the weightage to be given to an international law. But Cuiborex versus Bolivia had an interesting take on it. So, Cuiborex versus Bolivia, the tribunal had to look at or apply article 42. Then while interpreting article 42 of exit convention, the tribunal stated that it will decide on its own where to apply Bolivian law and where to apply international law, but it will take this decision so that the parties it does not apply legal theory that the parties are surprised that they didn't argue about it or the parties did not anticipate it. So, to that extent the Cuiborex tribunal had cautioned that we will not do such a thing, but we will take a decision as to where we will apply Bolivian law and where we will apply international law. So, that clarity also to some extent that clarity is there now because of this particular decided case. Okay, one is with regard to article 42. So, Article 42, please note, it gives a specific reference to international law, maybe because ICSID convention was adopted for, ICSID, what is the name of the ICSID convention? Convention for the Settlement of Investment Disputes between states and nationals of other state. So, it is anyway by international in character, the dispute itself is an international dispute. So, it makes sense that the ICSID convention also provides reference to international law as well. And since some of the investment disputes are decided under UNCITRAL arbitration rules, we look at whether there is a similar provision under UNCITRAL arbitration rules. Yes, Article 35 of UNCITRAL arbitration rules do talk about the applicable law. It also says that law as decided by the parties, and in the absence of such an agreement between the parties, then in that case what will be applicable as decided by arbitral tribunal that it considers to be appropriate. So, we can see a broad discretion is conferred on the arbitral tribunals that are constituted under UNCITRAL arbitration rules to hear investment disputes. There is no specific reference to international law, maybe because UNCITRAL arbitration rules were drafted to settle international commercial dispute. It was not envisaged, it was not drafted with the purpose of deciding an investment dispute where one of the parties is a host state, right. For whatever the reason, UNCITRAL arbitration rules only gives a broad discretion on the arbitral tribunal itself. So, now the tribunal, while deciding the question on what would be the applicable law, it will probably look at the international investment agreement. If that is not there, whether the parties have agreed to applicable law, either before the dispute was initiated or even if after the dispute is initiated, then it may also look to the relevant arbitral rules also, whether if it is an ICSID arbitration, whether the ICSID convention article 42 is applicable, or if it is an UNCITRAL arbitration, whether article 35 is applicable. So, that is there. Sometimes apparently the applicable law provisions also provided in the investment contracts. Now, we can see that the first 28 years after ICSID convention came into force, the tribunal constituted excessively relied on the applicable law that is provided in the investment contract, but we also see that there is a shift in that change post AAPL versus Sri Lanka case. Then the tribunal has been applying international law. So, that is that is because the arbitration happened pursuant to the investment contract. So, whether if the applicable law is provided in investment contract as well as applicable law is provided in a bilateral investment treaty, which one prevails, especially if there is a conflict between those two, what is it that the tribunal has to apply, that there is some sort of an uncertainty. But what we see here is that in case of US model India BIT of 2012, that sort of provides some answer to this particular point, and that is the US model BIT sort of brings a categorization of what sort of violations are claimed. So, in case if it is if the claim relates to a violation of bilateral investment treaty, then the applicable law mentioned in the bilateral investment treaty would be applicable. But if the violation is claimed with regard to an investment contract, then the applicable law mentioned in the investment contract would be applicable. So, this is how the applicable law question gets decided. Even if none of these work out, the tribunal can be seen to just talk about what is the thing. Just first at the beginning stage of the arbitration itself is lays down what are the things that it will look at, but mostly we can see that the tribunal prefers to apply international law, and one of the reasons that the tribunal prefer to apply international law is that the tribunals have, especially this is something that had come in the context of LG&E versus Argentina case. So, there the tribunal stated that a host state cannot justify a non-compliance with an international obligation by taking reference to a domestic law. So, that was one of the justification that is given here, and if we also look at Enron versus Argentina, there was a very interesting reasoning that the tribunal had given in this case. The tribunal referred to Argentina's constitution. So, there were certain provisions in Argentine constitution that gave a lot of significance to international treaties, and then Enron tribunal stated that your own constitution gives a lot of emphasis on international treaties, and therefore we will give international law a higher status. Whatever obligations have been assumed under international treaties, that would prevail over the content of domestic laws. So that I found to be a very interesting observation that Enron Tribunal had made. So now that we know how applicable law question gets decided, what is applicable law what is the law that will be applicable on a particular dispute. So once we have highlighted that, once the tribunal has highlighted that, then goes on to apply that to decide the violations of an international investment agreement.